Hello and welcome to the Disability Law Q&A with me, Martin Willemse. I'm a partner in Western Canada disability practice leader at the firm of St. Fruit American LLP. We've got offices in British Columbia, Alberta, and in Ontario, and we represent clients throughout Canada other than in Quebec and the territories. I welcome all questions through the social media platforms. We've got 30 minutes. I'll dive right into it. One of the things that have come up, well, it always comes up, is what happens when a person is on an approved long-term disability leave and they want to attempt to try to do a graduated return to work, and if they fail. So firstly, there are two definitions for total disability for the vast majority of people when they have a group policy. The first one would be you have to prove you cannot perform the duties of your own occupation. Then that definition changes. Usually the own occupation is payable for 2 years. Then it changes to any occupation for which the person may be qualified by means of their education, training, and experience that they could medically do, and that would pay to them an amount roughly equal to 2/3 of their pre-disability income. Graduated return to work programs are often supported by the insurance company and pushed for by the insurance company because they would like you to get off the claim. I don't think that's a controversial statement. There is a duty to mitigate, meaning that you have a duty as the person who is receiving benefits to take steps to get back to work. And that includes following through with the recommended treatment and appropriate treatment advice and trying to get back to work. When it is in the own occupation period, people often try and would be, I won't say pushed, but encouraged, strongly encouraged to get back to work by the insurance company through what is referred to as an approved graduated return to work program. So what may happen is there would be a rehabilitation program. Let's say it's a mental health illness. The person may have supported, paid for by the insurance company, return to work focused counseling in the form of cognitive behavioral therapy, with an expectation that at the end of those therapy sessions, the person will be in a position to return to work, even on a graduated basis. What happens if the person struggles with that? My advice to anybody who would be engaging in a graduated return to work program would be to see their doctor very regularly. So the very first thing is you want to make sure that you see your doctor prior to the graduated return to work starting, and that you have your doctor agree that you actually are capable of attempting a graduated return to work. If your doctor agrees, and the doctor agrees with the timeline that is set out, usually the insurance company has quite aggressive timelines. If the doctor agrees with a supported graduated return to work program, make sure that you see your doctor on a very regular basis during that period. Because if you find that your condition worsens or your symptoms become exacerbated or you simply cannot do it, you want to be sure that you have seen your doctor during that period so that your doctor can document not just what you report to the doctor, but also the doctor's own individual observations of you when you visit the doctor. So that if the doctor decides that the graduated return to work was premature or that you should not have engaged in it at all, and that is actually worsening your condition, the doctor can support that you stop working again. And when doing so, the doctor can provide a letter to the insurance company based on an informed opinion, because the doctor will have viewed personally and observed personally the decline in your health. If the insurance company then disagrees that you should not be pursuing or should be ceasing your graduated return to work attempt and terminate your claim, you will be able to be in a position, depending on if you're unionized, there's a collective bargaining agreement for most, but for most everybody else, you would be in a position to either appeal that decision or to pursue a legal claim. At our end, we pursue legal claims on behalf of clients. We offer free consultations. And when people contact us, we have a discussion with them about what their options are. So we would review the policy if it is available, review the denial letter and possibly medical records as well, have a discussion with you about your personal circumstances, and then advise you of your options. Those are free consultations. So if you do decide to pursue a legal claim, that is what we do. Our goal is to get you the best compensation that may be available. At least if you decide to have that phone call, you can make an informed decision as to what is the best option for you personally, because not everything is the same for everyone. Anyway, another thing to be said there, once a claim is denied, remember that there is something called a limitation period. A limitation period is the timeline within which you can pursue a legal claim, and it is not the same as the appeal deadline. People often get confused about this, and I'm not surprised. The insurance company in their denial letter will likely say to you that you've got this many 30 days, 90 days, sometimes longer, of time to appeal the denial. But further down, there may be another paragraph dealing with something called a limitation period. And not all of them are detailed as to how long that limitation period is. For most people, it would be 2 years from the date that the last payment was made. And it runs regardless of whether the appeal process is being pursued. So if you miss that limitation period, you will not have an opportunity to pursue a legal claim, other than in very limited circumstances. Anyway, let's have a look at more questions coming in. Okay, question on Facebook from Trevor. I was told my file was transferred to a new case manager. Since then, everything has slowed down and I'm being asked to resubmit documents I already sent. Can this affect my benefits? You should not really be put in a position where you have to resubmit documents that has already been submitted, provided that the insurance company has acknowledged that they actually received those documents, because it does happen sometimes the documents do go missing. If there is a delay in responding at their end, or if there is no communication forthcoming from the insurance company, I always would suggest that a person escalate. If there is a complaint, escalate the complaint to the powers that be, meaning the supervisor or the person's manager, etc., and continue to document every communication that you've tried to make. Any email that you've sent obviously will be in a written dialect, but it needs to be documented, all the attempts that you've made to contact the insurance company if you are not getting a response, so that when you do speak to a manager, you can escalate it and refer back to those issues. I doubt whether it will affect your benefits, because the ultimate issue would be, are you disabled or not? As long as your documents support that you're disabled, hopefully the insurance company will agree. If they do not, you know again what to do. You can contact us and we can have a discussion about what your options are. This is a question on Facebook again from Renee. I missed the deadline to appeal my disability denial because I was hospitalized. Is it too late, or do I have any options? Okay. This becomes a frustrating issue for many people. Often, the appeal deadline is an internal appeal system that the insurance company is mandating. It doesn't mean that it is detailed in the policy. The policy is a contract. The contract provides that you are entitled to benefits if you submit satisfactory proof of claim to the insurance company that you're totally disabled. Some policies, not many, some policies will actually address the appeal process, but for the vast majority, they don't. So it is an internal mechanism that the insurance company is using. If you miss that deadline, the position would be that the insurance company has an ongoing duty of good faith to entertain appeals and to support your claim if the evidence supports that you're totally disabled. In other words, to continue to adjudicate your claim. Because you've missed the appeal deadline, I strongly encourage that you contact us and have a discussion with us, because your question is also, do you have other options? If your claim is not jurisdictionally barred, yes, you may have an option to pursue a legal claim. And when people contact us, we discuss with them the differences between the two. With an appeal, you can get your monthly benefit, but you go back into the relationship with the insurance company who initially cut you off, who had denied your claim. With a legal claim, you do not communicate with the insurance company at all. You don't have to deal with the case managers. All communications go through the lawyer, who is pursuing a settlement on your behalf, while you can focus on what is most important, getting the best treatment so that you can recover from your disability. As you can see on the screen, you can go to disabilityrights.ca for more information. So Renee, I do encourage you to contact us. Yes, there are always options. Just because you missed the deadline for the appeal, they do have a duty of ongoing faith to continue to adjudicate the claim. Okay, a question from YouTuber, I believe, at Jared.Van My sister's insurer wants her to go for a medical assessment and said if she doesn't, they'll cut her off. Is this true? This has become a bigger thing these days. It's always been a thing, but I've seen this happen more often. Remember what I said, that the policy is a contract, and the contract has rights and obligations on both sides. One of the rights that the insurance company will likely have under the terms of the policy is for your sister to attend a medical assessment that the insurance company deems appropriate for her condition. So the first thing that I would suggest is have your sister request from the insurance company the policy and where they detail that they are entitled to have her attend the assessment. Secondly, is the assessment appropriate for her condition? Is the assessment carrying with it a risk that it may aggravate or exacerbate her symptoms? That doesn't happen that often, but it does happen. I can use an example of something that I've seen recently where the insurance company was mandating that the person attend a functional capacity evaluation of 2 days, where the treating providers cautioned against the person attending such an assessment because it had the very likely result, carried with it the very likely result, that the person's condition would actually worsen and harm them. The doctors would then write letters to advise that this was not an appropriate step, an appropriate assessment for the insurance company to insist on, and that the person needed further treatment, further recovery before they could engage in such an assessment. If the insurance company ignores that, and if that position from the doctor is grounded on a reasonable basis and is medically sound, the argument will be that if the insurance company then terminates the benefits when the person has satisfactory support, written support from their treatment providers as to why they are not in a position to attend such an assessment, I would argue that a legal claim obviously can be filed, but also that a claim for damages can be pursued. Because the insurance company obviously has to act reasonably as well and should not be exposing the insured person to any risk in the effect that they would be attending an assessment that would worsen their condition. That's not the case for everyone. So in some instances, it may be the person has a mental health condition and the insurance company is mandating that they attend an independent medical psychiatric assessment. I would still say have a discussion with your doctor about it, but if you do refuse and there's no contraindication to attend such an assessment, yes, it's very likely that benefits will be terminated, and then it would be a difficult claim to pursue if you are at your end breaching the terms of the policy. But of course, one shoe doesn't fit everybody, so there's always, and nothing's ever just black or white, there's always gray. So if your sister has further questions about this, she can contact us and we can discuss with her what her circumstances are and then give us some pointers as to how to proceed. Again, as you can see on the screen, you can go to disabilityrights.ca for more information. Then we've got a question on YouTube from Mars. I've been waiting over a month to hear anything from my insurer. How long should I expect to have to wait, and what do I do if I don't hear back? This comes up every now and again. So the insurance company, as I said, I always go back to basics. The insurance company has a duty of good faith to the person insured. And I would argue that that duty of good faith includes adjudicating, assessing, and making decisions on claims in a timely manner. When a person goes off work, they're obviously not receiving income. And when they make a claim for disability benefits, that claim should be assessed on an expeditious basis because the person is not receiving any income. So what to do if you do not hear back? If it's been 30 days, I would contact the insurance company's call center, find out who the person's manager is, and elevate any communications and complaints to that manager. And I would do that on a very regular basis until you receive communications. If you do not, contact us and we can have a discussion with you about what your options are. Document everything, put everything in writing, write to them, advise them when you submitted the claim, what communications or lack of communications that you've received, when that was done, all the efforts that you've put in and all the times that you try to communicate with them, so that if there were to be a legal claim at a later stage, all of that is documented. And again, an argument can be made that through a legal claim that there could be a potential award for damages. Okay. Another question on YouTube. This one is from Victor. I'm receiving CPP disability and LTD benefits. Can my insurance company reduce my payment because of CPP? Yes, this is an ongoing question. Always go back to, what does your policy state? If it's an individual policy, in other words, not through your group insurer, something that you went out and you purchased, sometimes those policies do not provide that CPP disability benefits are deductible from your LTD benefit. If it is a group policy, it is very, very likely that the policy will have an offset provision, and that CPP disability benefits will be a direct offset, which means that if you do receive CPP disability benefits, the insurance company will be able to deduct your CPP disability benefit amount. But I will say this with caution again, it depends on the wording of your policy. I have seen policies where CPP disability benefits are not deducted dollar for dollar, but it may be 90% of the CPP disability benefit amount. Then there's also a discussion about child benefits and about a cost of living allowance. When you receive CPP disability benefits, it would be retroactive, the payment itself, 11 months from the date that you applied. It would go back to whatever year. After that year, the next year, starting in January, there will be an increase. It's called a cost of living allowance. The vast majority of policies, disability policies, provide that the increase is not an offset under the policy. And many of them provide that child benefits that you receive as a result of your CPP disability benefit are not direct offsets, but they may be indirect offsets, which may mean that there's a different calculation that is used. It's not a dollar for dollar discount or offset as it would be with regular CPP. If your disability is a taxable benefit, you may also want to apply for the disability tax credit to help with tax consequences, because CPP disability benefits are taxable. I hope that was helpful. People often ask me, why should I do this? Why should I apply? Well, there are a few reasons. If your LTD benefit insurer denies your LTD benefit or terminates the LTD benefit and you're receiving CPP, then at least you continue to have some source of income. And as I said, the annual increase for the vast majority of cases would not be deductible from the LTD benefit. YouTube @senior.msh or _msh. My husband's doctor has told him that he needs to stop working so he can retain some mobility, but his insurer is pushing back, saying he is fit to do some work. What should we do? Okay, so reading that question, I'm not quite sure whether your husband is already off of work. The doctor told him to stop working, but the insurance company is saying back. So maybe the husband has stopped working and the insurance company is denying the claim. I mean, they are saying that he's still fit to do some work. The vast majority of policies have two definitions. The first one is that the person must prove that they cannot perform the duties of their own occupation. If that is the case for your husband, then doing some work, meaning some alternative work, other work, should not be relevant here. It is, can he perform the duties of his own occupation? Unless he's been off work for 2 years and he's now in the any occupation phase. Some work also should not be deemed as, you cannot say to somebody who is earning $100,000 per year, well, maybe you can go work earning $10,000 a year because you could do a little bit of work, therefore you're not disabled. That's not how this works. So for you, Selena, your doctor would have to put everything in writing as to what his opinion is, what the restrictions and limitations are, because a disability claim, more than diagnosis, is about functional impairment. If your husband cannot perform the duties of his own and any other occupation, depending on where he is within the timeline, and the insurance company is pushing back, You would have an option to pursue a legal claim, one would think, unless there's a collective bargaining agreement preventing such a process. So I would strongly encourage your husband to contact us, and we can offer to him a free consultation if he is not unionized with a collective bargaining agreement that prevents a legal claim, and we can discuss with him what his options are. I know it's a very difficult situation, but what I'm gathering from this is he's not working. The insurance company is denying him and want him to go back to work. This is exactly what we do, and this is exactly where people do get denied. The insurance company will be motivated to have your husband go back to work. If he is not in a position to go back to work and his doctor is advising that he shouldn't, likely option would be to follow the doctor's advice and to pursue some other form of process to make the insurance pay what is owed. So I strongly encourage your husband to contact us. I hope that was helpful. Okay, question on Facebook from Jamie. My doctor keeps sending medical forms to the insurance company, but the insurance says they haven't received enough information. What happens if they say my medical evidence is insufficient or isn't sufficient? That's one of the big reasons why claims get denied, is the insurance company will say, well, we've reviewed the information that has been provided, and the information provided is not sufficient to support that the person has restrictions and limitations that would prevent them from performing the duties of their occupation. So it becomes a difficult thing for people who don't deal with this on a regular basis. The reason why I say that is you will feel that you're at a crossroads. You don't know what to do. You've submitted all the evidence. What else can you do? Often, one would say that if the insurance company, if the doctor supports that you cannot work because of your condition, and the doctor has outlined what your restrictions and limitations are, and the insurance company hasn't done any assessment at their end, why would they say then that the evidence is not sufficient? Who made that decision? Somebody in-house? Some doctor in-house who has not had an opportunity to even see you, assess you, meet with you, speak with you? How are they in a position to overrule what your doctor has said? This is something that regularly happens. So for you, I'm going to sound like a broken record, but please contact us so that we can have a discussion with you. We'll review the documents with you. We'll look at what your doctors have sent. And if there is information that is missing, we will tell you that. If we think that the information is sufficient, we will also tell you that and then advise you of your options. You can try and beat against that wall of trying to get the insurance company to pay you in the context of having submitted so much information, or you can hand it over to a lawyer and pursue a legal claim. That decision is entirely up to you, but you need to know what your options are so that you can make an informed decision. Again, as you can see on the screen, you can go to disabilityrights.ca for more information. At nightingale.z3d says, and this is on YouTube as well, I've been struggling to get a diagnosis. My doctor thinks I should be off work, but we don't have a name to form the symptoms yet. Will I be able to go on LTD with this? This is a very good question. It's something that comes up fairly regularly. A disability claim is about functional impairment. What that means is, I'll use an example. If you have a mental health illness, let's say anxiety, and you go off work, and the doctor says, my patient has anxiety, therefore they cannot work, that claim is going to be denied. The reason why we have the diagnosis, but we do not understand why the person cannot work, because so many people with anxiety can work. It's about functional impairment. So if you have a claim, or if you have a condition, because you've had symptoms, those are medical symptoms. You just don't know what the condition is. And unfortunately, in a very, very broken healthcare system, people struggle to get through to proper investigations, and it can take months, if not years, to get in to see a specialist and to follow through with MRIs, what other investigations may be happening. So if your condition is such that you cannot work, the doctor can detail what the restrictions and limitations are. If there's a suspected diagnosis, that can be listed as well. I'm sure you are being referred to specialists, because if the doctor isn't sure what's going on, surely there must be a recommendation or referral made to specialists. The doctor can detail that as well. Is it a more difficult claim to pursue? Yes, it is. I do believe you will struggle with that. Having said that, if there's a denial, again, there may be a way to pursue that through a legal claim. Obviously, the goal is not to have it denied. So the doctor would have to detail what the symptoms are, what the restrictions are, what the limitations are, what experts you have seen, what treatment you have engaged in, and what investigations you've done, and what referrals are coming, and what referrals and investigations are pending. Do as best a job as possible to outline why the person cannot work or why you cannot work. And hopefully, you will not have to reach out to us if the claim is denied, and the insurance company will be helping or approving the claim. If you have more questions on that, you're welcome to contact us and we can have a discussion with you, because there may be a bigger discussion that needs to be had regarding what I've just said. The goal is to get your claim approved. Of course it is. So if there's a denial, that's when we get involved. But I'm hoping that you don't have to go through that process and get your claim approved. At YouTube at Pycon9004 says, my wife has severe obstructive sleep apnea. Is she eligible for LTD? Somewhat goes back to the previous question that I just answered. We often get questions from people as to, I have chronic migraines. Is that a disability? Or I have complications because of this condition. Is that a disability? Any condition that is preventing you from performing the duties of your occupation, and if it's obviously a medical illness, should be considered as a disability under the terms of the policy. Severe obstructive sleep apnea may lead to other medical conditions, heart conditions. It may lead to extreme fatigue because the person isn't able to sleep. So when they are awake the next day and they've only had 2 hours of sleep, they may have brain fog. They may have difficulties with cognitive functioning. For example, cannot focus, cannot concentrate, cannot memorize things, cannot multitask. That may lead to anxiety. All of those things will need to be treated. So going back to my previous point, a diagnosis is important. I'm not going to deny that. Of course it is important. We need to understand what the condition is. But what is more important is functional impairment. Why can the person not work? Lots of people have sleep apnea. They use CPAP machines, which for the most part one would think is quite helpful. But again, not everything is black and white. There's a lot of gray. So if the person is struggling, if your wife is following through with recommended treatment, she's using the machine, it's still not helping, it's affecting her in many other ways, and it's affecting her ability to function, as long as she has appropriate medical evidence from the treatment providers showing that what the condition is, what the functional impairment is, in other words, what are the restrictions and limitations. And remember what I said, not sleeping, fatigue, cognitive impairment, maybe mental health illness as a result of the stress of it all of that needs to be detailed. And then the doctor can opine why your wife is unable to perform the duties of her occupation. For example, if it is a person who has to work as a bank teller, where you have to focus, you have to deal with the public, you're working with other people's money, you may be able to have to multitask. If all of that is compromised as a result of the restrictions and limitations occasioned by the medical illness, meaning obstructive sleep apnea, that may lead to a finding of disability. But make sure that your wife is under the regular care of a physician, following through with appropriate treatment, and have a discussion with the doctor as whether the doctor supports that a disability claim be filed. If that claim is denied, I'll say this for the last time, you're welcome to contact us and we can discuss with your wife what our options would be. Again, those consultations are done on a free basis. You can go to disabilityrights.ca for more information. And with that said, the 30 minutes have flown by, so thank you for all the questions. Our next session will be an employment law Q&A, which is tomorrow, January 28th at 1 p.m. Eastern Standard Time, 10 a.m. Pacific Standard Time with my partner, Lior Sanfuru. I wish everybody a great day, and we'll see you again in 2 weeks to do another disability law Q&A. Thank you.